I'm Ben Meiselas from the MeidasTouch Network. Special Counsel Jack Smith just filed probably the most powerful brief, not only in the criminal prosecution of Donald Trump in the federal court case in Washington, D.C. for Donald Trump's attempt to overthrow the results of the 2020 election. That case is set for trial in March of 2024. But this brief that Special Counsel Jack Smith just filed that I'm going to discuss with you may be the most powerful and important legal brief in recent legal jurisprudence history. It is that powerful, standing for the proposition that no one is above the law. The motion that Donald Trump filed was seeking absolute immunity for his conduct arising out of the January 6th insurrection and Donald Trump's broader conspiracy to try and overthrow the results of a free and fair election. Donald Trump is trying to dismiss the prosecution by Special Counsel Jack Smith and the government of the United States. Special Counsel Jack Smith responded in the government's response in opposition to criminal defendant Donald Trump's motion to dismiss the indictment on presidential immunity grounds. Folks, listen to how powerful these words are by Special Counsel Jack Smith and his team. Defendant Donald J. Trump moves to dismiss the indictment, asking the court to afford him absolute immunity from criminal prosecution for what he expansively claims was official conduct during his presidency. That novel approach to immunity would contravene the fundamental principle that no man in this country is so high that he is above the law. The defendant is not above the law. He is subject to the federal criminal laws like more than 330 million other Americans, including members of Congress, federal judges, and everyday citizens. None of the sources the defendant points to in his motion, the Constitution's text and structure, history and tradition, or Supreme Court precedent, supports the absolute immunity he asks the court to create for him. In staking his claim, he purports to draw a parallel between his fraudulent efforts to overturn the results of an election that he lost and the likes of Abraham Lincoln's Gettysburg Address and George Washington's farewell address. These things are not alike. The more apt parallel the defendant identifies is to judges who, like a former president, enjoy absolute immunity from civil damages liability for certain conduct, but who are subject to criminal prosecutions as are other citizens. The same is true for the defendant. For the reasons set forth below, the defendant's motion to dismiss the indictment based on presidential immunity should be denied. This response in opposition by Special Counsel Jack Smith's team then goes on to talk about the factual and procedural background in this indictment that is being prosecuted in Washington, D.C., and then it goes into the argument section. And watch how Special Counsel Jack Smith picks his words so intentionally, so specifically, not superfluous. This is the kind of legal work that is so impressive. Goes on to say, an individual who has served as President of the United States but is no longer in office may face investigation, indictment, trial, and if convicted, punishment for conduct committed during the presidency. No court has ever alluded to the existence of absolute criminal immunity for former presidents, and legal principles, historical evidence, and policy rationales demonstrate that once out of office, a former president is subject to federal criminal prosecution like other citizens. Goes on to cite United States versus Burr, a case from 1807. The president is elected from the same mass of people, and on the expiration of the time for which he is elected, returns to the mass of the people again. Indeed, a contrary rule would violate the fundamental principle that no one in this country, not even the president, is above the law. The defendant Donald Trump's novel request for absolute immunity directly conflicts with the Constitution's impeachment judgment clause, Article 1, Section 3, Clause 7, which expressly contemplates the criminal prosecution of a former president for acts committed during and ultimately resulting in the president's removal from the presidency. That provision ensures, among other things, that an officer who has been removed through impeachment cannot seek refuge in principles of double jeopardy to avoid criminal prosecution. The defendant, however, would turn the impeachment judgment clause on its head and have the court read it as a sweeping grant of immunity that forbids criminal prosecution in the absence of a Senate conviction, which, among other things, would effectively preclude any form of accountability for a president who commits crimes at the end of his term of office. The defendant dismissed this very approach to the impeachment judgment clause as nonsense and a complete canard during his second impeachment trial, and the court should do the same here. A president already enjoys two forms of immunity designed to afford protections to the discharge of his wide-ranging duties, but neither the temporary immunity from criminal liability that an incumbent president enjoys while in office, nor the absolute immunity that current and former presidents enjoy from civil liability for their official conduct as president, suggests the existence of an unprecedented form of absolute immunity from criminal liability. To the contrary, the existence of both immunities is premised on the availability of criminal liability once a former president is out of office. The defendant's motion to dismiss should be denied on the ground that a former president cannot claim any immunity from federal criminal prosecution, even if the defendant had satisfied his burden to establish that a former president could claim some heretofore unrecognized and novel immunity from criminal prosecution for certain acts committed during his presidency. Denial of the defendant's motion is nonetheless warranted. Recognizing immunity from federal criminal prosecution for a former president would pose substantial challenges regarding its scope and application, and the defendant provides no suggestion or support for how to navigate such challenges. At a minimum, any such criminal immunity would, consistent with the reasoning in Fitzgerald and the balancing in the United States v. Nixon, be narrower than the outer perimeter immunity applicable in the civil context and would have to reflect a consideration of mens rea, since otherwise even clear cases like bribery would be excluded. The defendant has not shown that the conduct alleged in the indictment would fall within the boundaries of any plausible understanding of such a novel immunity from federal criminal prosecution. And even if he could claim immunity from criminal prosecution for official conduct while in office, comparable to the broad immunity from civil liability recognized in Fitzgerald, dismissal is inappropriate because the defendant cannot plausibly claim that every allegation in the indictment involves acts within the outer perimeter of a president's official legal responsibility. Powerful words. Just going through some of these sections, a former president has no immunity from federal criminal prosecution. There is no constitutional provision or historical practice that supports it. The Constitution does not support absolute immunity at all. Historical practice does not support absolute immunity at all. The immunity from civil liability for a former president's official conduct recognized in Fitzgerald does not extend to criminal liability, and even if it did, Donald Trump's acts would not fall within the outer perimeter of the immunity scope. Donald Trump's conduct is far outside that. It would make absolutely no sense to immunize someone using the constitutional powers where someone's goal and aim was to destroy our Constitution. I'm Ben Meiselas from the MeidasTouch Network. I'm confident that Donald Trump's motion to dismiss will be rejected, and this case will go to trial in March of 2024. Hit subscribe. We are on our way to 2 million subscribers. And check us out at patreon.com/MeidasTouch. Have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.